All right, folks. I think I get it, but let me see. I read it. So do you have a lease with this gentleman, Mr. Edwards? No. I see on the complaint you allege that you gave him a 60-day notice. I take it he moved in on a gratuitous tenancy, and then you've since given him a notice. When did you give him the 60-day notice?
Back in October.
Okay. All right. And you filed this here back on December 29th. Okay. You're not looking for any money. So let me turn it to Mr. Edwards. Mr. Edwards, did you have a written lease with Miss Cassiano?
No, I did not.
All right. Any money that you had been paying her?
No, I haven't been paying her any money. We had an agreement back in August that I would maintain utilities.
Okay. All right. So tell me what's going on. Why are we still there? Mr. Edwards?
Oh, it's on me. Okay, I apologize.
You're the defendant, man.
Yeah.
He said she gave you the 60-day notice. Did she give you the 60-day notice?
No, I don't have any notice. I don't have any proof of a notice. I don't have any mail. No transactions that came through my mail in regards to a notice.
Do you guys live at the same place, or you live in a different place?
She doesn't live here. She doesn't live here any longer. No, she moved in August. She moved from the property in August. We found the home and moved into the home together when she purchased it back in November of 2024.
Are you paying the mortgage now?
No, I'm not paying the mortgage currently.
Who's paying the mortgage?
I'm not 100% sure from what I'm looking at.
How do you think you can stay there though, bro?
How do I think I can stay here? Well,
if you're not paying any rent, you don't have any lease with anybody, and it's her spot.
Well, she no longer lives here. The reason why she left is because she decided to go elsewhere. She advised me that.
So is this her place or your place?
This is her place, correct.
So just help the court understand that you're saying she moved out, you're not paying her no rent, and you just staying there. Do you plan on moving?
Yes, I do plan on moving, Your Honor.
When do you plan on vacating?
Well, I wasn't planning on moving until the court stated that I had to move from the property.
Why wouldn't you move?
Well, the whole thing is, once she left the property, she advised me that all I would have to cover is the utilities. So I was going off the basis of that. She said around January we would have to come.
Have you been paying the utilities?
Yes, and I paid the utilities, and then she cut them off. She cut utilities off a day after I paid them.
So what utilities are off at the moment?
At the moment, I had every utility turned back on. Afterwards.
In your name or her name?
In my name, correct.
How did you get them turned on in your name if you don't have a lease?
I'm not 100% sure. That's what they allow.
What did you give them to say that you lived there?
I gave them utility bills for the internet. I've been paying the internet bill since we moved in.
And that's in your name?
Correct. The internet's been in my name since the beginning of time. Yeah.
So you showed them that you were paying the internet bill, and then they figured you lived there?
Exactly. That's what happened.
Okay. Ms. Cassiano, how did you provide him the 60-day notice?
I hired an eviction company, and they went ahead and stuck the notice. I actually sent an email with the attached to the email address for the court. We also had a confrontation back in October and November, and he showed the police officer the notice that he received, and he was complaining that it wasn't legit. Okay. He also
did you submit that to the court for us to review?
Yes, I did through email.
Clerk, can you see if we can add that to the? I don't see it yet.
Can you also take a look at the email Jeremy sent you and look at the pornography that he sent you of me having oral sex with him?
I don't have any of that. I'm gonna be honest with you.
He sent it to the court as well.
Well, he shouldn't have done that.
Yeah.
But I don't have any of those documents. So I guess what I'm trying to figure out is, she's saying you gave the notice. You're saying you didn't get the notice, and you're saying you're there and you're gonna be there until I tell you to go.
Well, the thing is, it's a little more complex than that.
What's more going on?
So, I mean, because I spoke with my mother about the situation, and we were trying to assume the property from her. We were trying to
Are
get
you
the
trying
property
to take the property from her?
by by an agreement. It wasn't necessarily like, you know,
Bro, listen, man. How old are you?
I'm 38.
When's the last time you gave her any money to live there?
September.
$150 for a bill?
Are you guys still together?
No.
No, we're not.
When'd you break up?
When I left in August. And he had other females in my house. I paid a $2,000.
Mr. Edwards, I'm just asking you these questions while I'm waiting for this stuff to come in, because if it's her property, you ain't got no lease and you stay in there, I'm trying to figure out why you still want to stay there.
And I wasn't even asking him to pay anything for the last 5 months that he's been there by himself.
And brother, is that a do-rag?
Take that off in the court.
You know you really shouldn't rock do-rags while you're in court, brother. But
no, I completely understand. Just because I seen everyone else in the courtroom, it just seemed like, you know, everybody was kind of, you know, in their cars and things of that nature.
I understand. All right, I'm just waiting. Clerk, let me know if you can upload those documents.
He also, I have the house up for sale. He also just sabotaged a showing by not allowing the realtor to show the house.
Okay.
And that's why the last realtor, Brenda Dollars, didn't want to work with me, because she knew he would do stuff like that.
Okay.
So I have until the 31st.
It's okay. I'm just waiting to see about the notices, so just hold tight.
Okay.
Your Honor, I also have included a timeline of multiple things, harassment that I received from this woman.
To get out my house.
Property misappropriation, removing of the blinds, my privacy.
I bought them. It's my house. I could take them down if I want to.
Folks, just hold tight, man, because this is, you know, I'm not gonna get into your relationship issues.
Yeah, no, I understand.
This is the second case I've had this evening, and I don't know why people even live with each other no more. Because you living in a spot that you don't own and ain't paying no money towards it. And
Never
she living
has.
in another spot.
And
now you trying to buy it from her. It just sounds like something out of a movie. But if you have not given him notice, man, he gonna get to stay. So I'm gonna just be 100. So we'll see if the notice is there.
Sure.
Now, Mr. Edwards, I'm gonna tell you now, I'm gonna give you an opportunity, brother. Did she give you the notice or not? Because if I find a notice and you tell me she didn't give you notice, I'm gonna feel a little perturbed with you, and I'm gonna feel like you've been lying to me.
Your Honor, I have not received any notice, no certified mail, anything of that nature. This company that she's referencing, I just found them on the document.
The company I'm referencing that served you the notice? Is that what you're talking about?
The company that served that's on the attorney for this hearing that we're having today.
Oh, now, Mr. Edwards. Now, I don't know why I can't. Let me see if I can share my screen.
Yeah, I'd like to see what she's referencing as far as she submitted.
Me too?
The same thing you were crying to the cops about.
Hold on.
I showed the office.
Folks, just hold tight. I'm gonna show you what I have, and then you guys can dispute there. Can you guys see that?
I can see it.
Yes, I do see it, Your Honor.
Okay. All right. Is that your front door?
Yes, that is.
Is that address?
Yes, that is.
All right, hold on. I got another one. There's another picture. Is that it?
That's our side door.
Now this says October 25th, 2025. You don't remember seeing that on the door? Does anybody else live there with you?
Only him.
I have multiple people that she stated previously. I have multiple people that come here.
What, somebody would just take that off the door for you that says your name?
We've had break-ins and all different types of things happen in this neighborhood.
So somebody break in and take off a 60-day notice of termination of tenancy when that's what they stealing these days?
Someone broke in and stole sneakers from out of here. All different.
This ain't a sneaker, bro. This is a notice to leave. You don't remember seeing this? You've never seen this before.
Your Honor, I'm telling you, what I stated was the truth.
Well, so I'm gonna tell you this. She has provided pictures and evidence that this was posted to the door. And with a timestamp, as well as the date of the letter as well. So, I mean, this is pretty strong evidence.
I completely understand. That doesn't mean, I mean, this could be fraudulent as far as I know.
It could be,
I have,
but this is why everything's evidence. It's a preponderance of the evidence. Okay, this is not a criminal case, and I'm trying to. She's provided evidence that she's done the duty of the law. You're saying no. What evidence do you have to contest that?
the evidence I have to contest that I provided as well. It's many different self-eviction tactics that she utilized as far as cutting off the electric, cutting off the water, cutting off the gas.
How long did that happen? How long did you not have gas or water?
I didn't have electric or gas for approximately 4 days. The water, I was able to catch the guy outside while he was cutting it off, and he just said, you know, fill out this paperwork. I'll keep the water on for now, but you know, that was a scenario there.
All right, so let's do this. I'm gonna go through it real quick. She gave you the 60-day notice. I'm gonna side with her based on the evidence of that. Beyond you're telling me that there is these issues associated with the water and utilities that you were ultimately able to get in your name. Well, is there anything else you'd like to let the court know or raise?
There's several of the things that I've added. She's been harassing me, over 100 phone calls that I've received from this woman. I run a business from home. I have a marketing agency. She goes on my marketing agency groups with multiple fake pages. I submitted this stuff as well. She left comments, nasty comments, personal information on my business pages. Things that clients of mine have seen.
You didn't, okay, that's fine. And I'm trying to see if I can come up. Clerk, do we have any of that as well? Did he submit it? Did you submit that to the court?
Yes, I did.
Hold on, I'm gonna see, looking for it right now. Here it goes. Okay, this is a chronology of events.
Can you go to?
There's two submissions. I'm sorry.
Can you go to zip file E?
No, I don't have a zip file E here, but I do see Exhibit E, social media.
Okay.
But I don't see where there's a zip file for me to.
Okay, well, in there, there's videos of me.
Okay, exhibit. Well, folks say.
Your Honor, if I attach the incorrect video, trust me, it's not.
You attached the incorrect. Is that what you're telling the court?
Of me giving oral to him.
Well, nobody else knows that, ma'am. But whoever's so you don't have to mention that, okay? You don't have to make it worse.
I'm just confused on how that would be an accident.
No, that's not appropriate.
Why would that be intentional? Why would that be intentional, Your Honor?
Well, Mr. Edwards, is there anything else that, well, because I'm not gonna lie to you, Mr. Edwards, I've seen all types of things doing this, but anything else, Mr. Edwards?
I have multiple things in the exhibits. If there's nothing that you
what in the exhibits would you want me to look at?
I'm trying to open them up here now. I apologize. I have so many notes from the past 2 years of different harassment things and tactics that she utilized.
What pertains to the 60 days and you not getting out of the house? What pertains to this scenario?
Well, hold on, Ms.
Sorry.
It's okay. It's all right.
I apologize, Your Honor, but it's kind of difficult for me to maintain my focus at this point.
And why is that?
Just the consistent interjections.
Well, don't worry, I got it.
I understand.
Anything else?
I'm trying to open up the file myself just so I can get a better look at what it was all submitted. I have payment receipts that are in there, self-eviction evidence, shut-off notices in there. I
am looking at that, but some of them I can't get. Oh, I do see the gas cutoff notice. This was back in October.
Mm-hmm. And then also we have a code violation hearing. That's Exhibit F. That's supposed to be on February 17th, if I'm correct.
And what is that regarding?
Yeah, what is that?
That's in regard to once the water was the request for the water to be shut off was set. Code enforcement was notified, and they just got to the property on December 29th.
Did you tell her about any of these things?
She was aware of it. I actually had a phone call with her.
No.
not,
Well, so let me do this.
yeah, see, I'm trying to talk. I'm sorry.
No, it's okay. But you said, how did you provide it to? Because the only concern that I have, I'll be honest with you folks, and I'll just be straight to it. When you're talking about these things that have serious implications, right? And when folks are not really communicating, like I said, we just had another hearing, and someone's in the other person's property. Obviously, they can either be foreclosed on, they can have other penalties that occur purely because you folks don't get along, and that's your prerogative, obviously. But if you want things to be done, you do need to notify the landlord because they can't do anything if you don't do it. Now, if you said you had a conversation with her, okay. And Ms. Casino, are you saying no? He's saying yes. Conversations, obviously, there's no record of that. This is the same thing with the 60 notice, right? You put a record, we have a copy, then we don't have to talk about he said, she said, right? So we don't want to get into all of that. Did you give her any written notice? Did you give her what you submitted to the court? Did you ever give her a copy of that as well, as far as the code compliance hearing?
No, a copy of that was, I was told by the code enforcer exactly where, as soon as he left, he said, I'll get this information to her and you'll have this court date. He handed me an orange paper that goes on the door. It was similar to one of these type of notices.
Yeah. I'm familiar.
He told me he was going to handle it. That was that process in that regard. But prior to that, I did explain to her, once I told her, hey, I want to assume the mortgage, take over the property from you. Don't worry about anything like that. And I told her,
what if she doesn't want to do that?
That's completely up to her. Exactly. There's no harm, no foul. You know, it's just an option that I gave out there so she wouldn't have to assume any longer financial responsibilities to the property. That was my whole thought process behind that. It wasn't like me trying to, set up a smoke screen and, steal a house or something.
No, I get it. Listen, it sounds like you guys just reached a disagreement. You really didn't have any real agreement. And then ultimately she sent you the 60-day, let you know whatever agreement you may have had has been canceled. Is there anything else, Ms. Cassiano?
I did swear we raised our right hand to not lie, but I didn't receive any documentation, no phone call, no message, no email, no nothing in regards to any code violation. And how would they handle it and get me the information? How would they do that?
Well, like I said, now you're aware you might want to inquire about that because those do have some impacts.
I don't even know who to contact.
You might want to contact the Cobb County Code Enforcement. If you're not aware, or Mr. Edwards can give you that, you can even take a picture of it and send it to her. And I believe the evidence that has been submitted may be ultimately uploaded to the file and you may be able to see it there. But I will say, Mr. Edwards, some of the information that you provided me in those exhibits, I wasn't able to open. Some of the videos, and I think some of the evidence that you were referencing as far as the evidence of harassment, those particular, not what I tried to click them, but they just wouldn't open for me. But I did see the issues about the cutoffs. So let me just make sure I address it so everybody feels clear. What I have right now, Mr. Edwards, is that she gave you the notices. And so we've got that. The other issues that we have are about the cutoffs. And I do think that that's significant because Ms. Cascassiano, as I've told the other young lady, you cannot cut off utilities. That is essentially you trying to force the eviction. Now for Mr. Edwards, he was able to get them cut back on. Now, like I said, whatever way he was able to get them cut on, he got them cut on, and that kind of partially rectified that issue. But you guys also never really had any formal agreement about rent. You never really had any formal agreement about any payments. And ultimately, right, you guys kind of had a gratuitous tendency, which she's giving you the notice that she wanted to cancel. So in that regard, I feel like you guys have met your she's met the burden to have the writ of possession issue. Now, she's never asked for any money. And I don't see really a basis counterclaim at this juncture that would entitle you to any money from her, since there's no money, there wasn't any money that she was pursuing against you either. Yes, Ms. Cassiano.
I didn't even ask for the electric and the gas bill that went to collections because he didn't pay it.
And that's why that's not relevant, because you didn't ask for it. So we're not even going to get into that. Right. But Mr. Edwards, I just want to let you know, I'm going to give you to January 22nd. That's all I can give you. I can't give you more than 7 days. 2026 at 11:59 p.m. Okay. And that'll be the order of the court. I really pray y'all get it resolved without more court involvement and it don't go any further than that. But either way, that'll be my order. Okay.
Thank you.
All right. You guys are welcome. Thank you.
Your Honor, I have another question though.
Yes, sir.
What if I wanted to further your determination? Is there any way I can go about that?
Yeah,
Is
you can
there-
appeal. Everybody has a right to an appeal as a matter of law. You got 7 days to appeal.
Okay, and I do that by stopping by at the.
You can speak to them, yes.
Okay, sounds good. Thank you. I appreciate your time.
No worries, man.
And excuse me,
Mm-hmm.
I have my house needs to be out of my hands by the 31st because I'm going through a short sale. My house is on the market. He's prolonging that and it's going to affect my credit.
Can I tell you something, folks? Let me just
He's
tell
had
you.
more than enough
Wait, just
time.
stop. Let me tell you something. I've made my order. Whatever he does past my order is what he does. As far as, let me just tell you this. Transfers of property can occur with other people still in the property. So I just don't be overly concerned about that. That's my order. Hopefully things get together, but you have to the 22nd, 2026 at 11:59.
Is there
All right. And
anyway?
watch that do-rag when you go into court next time, man. I'm gonna let it happen because I didn't say anything till late, but that ain't a courtroom appropriate, man. You got to always make sure you look your best when you're in front of the court, okay?
I'm aware. I put on a button up, but I just forgot the do-rag on.
Yeah. All right. You guys have a good evening.
All right. You take it easy.
Yeah. Mm-hmm.
Thank you, Your Honor.
You're welcome.
This case spirals fast. A breakup turns into a property battle, no lease, no rent, utilities cut off, alleged harassment, and even inappropriate evidence sent to the court. One party says notice was given. The other says it never happened. Now the judge has to decide who has the legal right to stay and who has to go. Now this is where credibility becomes everything. Mr. Edwards flatly denies receiving notice. But notice in eviction law doesn't always require certified mail, it can be posted to the door. The judge is carefully setting a trap here. He's giving Mr. Edwards an opportunity to be truthful before evidence is shown. Because once documented proof appears, denying it could damage his credibility in the court's eyes. And in civil cases, credibility often outweighs emotion. Notice how the judge narrows the scope. Mr. Edwards brings up harassment, social media attacks, even alleged inappropriate content submitted to the court. But the judge refocuses what relates to possession of the property. Civil courts are about relevance. Emotional grievances, relationship drama, none of that determines legal possession. Without rent payments, without a lease, and with valid notice proven, the law favors the property owner, and there's the ruling. Possession granted to the homeowner. Mr. Edwards gets 7 days to vacate with the right to appeal. This case is a textbook example of why informal living arrangements can turn disastrous. No lease. No rent. Verbal promises. Emotional fallout. In the end, courts rely on documentation, timelines, and legal standards, not feelings. Of the judge balanced both sides. He acknowledged the improper utility shutoffs, but ultimately enforced property rights once notice was proven. Now I want to ask you, do you think the judge made the right call? Should the alleged harassment have weighed more heavily? If you found this case as shocking as we did, hit like, comment your thoughts, and subscribe for more intense courtroom breakdowns.